Good morning. Today, our government is taking action to update Ontario's privacy and access to information laws and strengthen cybersecurity across the public sector. Ontario's current framework is nearly 4 decades old. It was written before email, smartphones, cloud computing, artificial intelligence, and today's cyber threats even existed. Quite simply, it no longer matches how government works or how people expect their information to be protected. That's why we're moving forward with a clear, balanced, and future-ready package of reforms, starting with protecting the integrity of cabinet decision-making. Ontario is one of the only jurisdictions in Canada without explicit protections for records belonging to cabinet ministers or their offices. This weakens clarity of protections for cabinet decision-making and undermines the candidness of critical, confidential discussion. Ministers need to be able to receive candid, evidence-based advice. We are fixing that gap by taking the necessary action to exclude cabinet ministers and their officers from FOI requirements and bring ourselves more closely in line with the approach taken by other jurisdictions across Canada. To ensure robust requirements remain in place and political direction to civil servants is still accessible to the public, and records with a public servant will remain subject to FIPA via the records of the public servant. We are also modernizing freedom of information and privacy rules. These changes will streamline FOI processes to provide clarity and certainty to the framework for a more flexible, modern approach. We are also strengthening privacy oversight and extending key protections to municipal institutions. Lastly, we are strengthening cybersecurity and protecting children's data. New requirements will ensure hospitals, colleges and universities, school boards, and children's aid societies meet baseline cybersecurity standards. Parents will be notified when children's personal information could be disclosed, and sensitive cybersecurity records will be protected from disclosure where they could put systems or people at risk. Taken together, this is a practical and responsible modernization. It will create a more responsible and secure digital framework for the province, enhancing information flow, strengthening privacy protections to reflect how modern governments operate. Thank you, and now I'm happy to take questions.
Minister, was this government being too transparent? Is that the problem you're trying to solve here?
The issue we're trying to solve is to ensure that Ontario is in line with other jurisdictions across Canada which have these protections in place vis-a-vis cabinet confidentiality.
But cabinet confidentiality is already protected under Section 12. You mentioned advice to cabinet ministers. That's already protected under Section 13. What is the problem you're trying to solve?
Yeah, as I mentioned, this particular program that we are initiating is modernizing legislation that was 40 years old. This was not contemplated 40 years ago. We didn't have cell phones. We didn't have cloud computing. We didn't have even email. Email was very new at the time. So these things were not contemplated when this legislation was written back almost 40 years ago. So we're modernizing the system, bringing it in line with the majority of other Canadian provinces and indeed the federal government.
Were there too many text and email requests? Was that the issue? Like what are the records, since ministries will still be subject to the law? What are the types of records or information in cabinet minister offices that you don't think should be public?
As I mentioned earlier, we are focused on cabinet confidentiality with respect to within ministry decisions. We think candid decision-making works for the benefit of the people of Ontario. And as I say, when this legislation was written 40 years ago, these kinds of communication weren't even contemplated. So this brings us in line with the majority of Canadian provinces. In fact, the only province that we are currently aligned with in the entire country is Nova Scotia. So most provinces and indeed the federal government have legislation somewhat similar to what we're proposing today.
So, Minister, if it's about cabinet confidentiality, why don't you tweak Section 12 then, rather than removing all ministers' offices, the Premier's office, from the legislation entirely?
Let me be perfectly clear here. Although we are encouraging cabinet confidentiality to have these kinds of candid discussions, there still will be FOI requests available, so any decision-making, openness in decision-making will be available through the public service. So those will be fully available. So the overwhelming majority of FOI requests that are coming in today will still be able to be FOI'd.
Is this going to apply retroactively?
This will apply retroactively.
There's so many stories, Minister, so many situations in the last few years that have only been made public, rightly so, through FOI requests to cabinet ministers and Premier's office. What would you answer to people who might ask you if you have something to hide?
This government has probably been one of the most transparent governments in the history of Ontario. When we first came in office in 2018, the first move we made was to open the books. We brought an independent auditor in to take a look at the books. The previous Liberal government was hiding a $15 billion deficit. We opened that up. That led to the Fiscal Transparency Act, which we initiated as well, which the finance minister has obligations to meet his budget on time. If he doesn't meet it on time, he will actually pay a penalty. And we have to explain deficits. Further to that as well, just in my ministry in the last year, we've had some issues with some regulatory authorities. You may be aware of the issue dealing with RICO. I ordered an independent audit of that organization, which we brought to the public through the Denton's report to see where the failings were within that organization. So we're very focused on transparency.
How can you continue to call yourselves one of the most transparent governments and then make this change? Do you still consider yourself one of the most transparent governments with this change?
Absolutely. I have a long list of things we've done to bring transparency to the people of Ontario. And whether it's the open data catalog that we have, as you may be familiar with, we've actually expanded the data processing information available on that open data catalog to the public, to journalists. You're able to use that free of charge at any time. So this is a government that is very, very focused on that. We've also, with respect to the regulatory authorities, for example, that report to my ministry, like the Home Construction Regulatory Authority, RICO is another one, FSRA doesn't report to me, but we've initiated open discussions with those organizations and legislated such that they need to report where there are license requirements, and making consumers more informed by their decision-making, I think, has been a critical part to our government's focus. So absolutely.
To put this really simply, how does hiding a bunch of political records and lengthening the timelines make your government more transparent?
Listen, this government's focused on a few things. Number one is transparency. I touched on a few things that we are currently dealing with. But second, if I could finish. Other components to this legislation that we're initiating today, which you haven't touched on, is protecting children's data. I think that's critically important. We are being open and transparent with the parents of Ontario. I, as a parent, I have kids in school myself. I'm now going to be informed when my children and their information is accessed by software providers, for example, in their schools. I think that's an incredible win for parents across the province of Ontario to have that kind of transparency. The other thing I'll mention as well is with respect to security. This province right now, the province of Ontario, has 1 trillion cyber incidents a year trying to interact with the public service. Let me repeat that. That's 1 trillion incidents. We have an incredible cybersecurity team dealing with this. But those incidents where they put the security of the people of Ontario at risk are no longer going to be FOIable as well. And that's working in the best interest of the people of Ontario to protect sensitive data from falling into the hands of bad actors.
Respectfully, you didn't answer the question. You did not answer the question, sir. How is hiding these records and lengthening these timelines, slowing the timelines down, more transparent for the people of Ontario?
I did answer the question. As I say, what we are doing, we're following the tradition, the Westminster tradition of cabinet confidentiality, which even in a recent court case with the Supreme Court of Canada sided with the government in terms of expanding the definition of cabinet confidentiality.
There's an inconsistency in your statement, because Auditor General reports have found politicalized decisions around what the ministry staff should be doing. So if we're only supposed to have the access to ministry staff, the fact is that politicians are also making decisions, and we're not able to, or the public is not able to access that.
Well, 2 points to that. First of all, the Integrity Commissioner and the Auditor General will still be able to compel documents from ministers. So let me be very clear on that. The second point to that is any decision-making that comes about obviously will be in contact with the public servants, and those decisions will be available on FOI. So they'll be fully transparent.
Minister, at the moment, there is a matter playing in court that dates back to the Greenbelt scandal. It involves a political staffer who does not want to relinquish records that the IPC has ordered him to relinquish. Will these law changes nullify that? Will it end that court case? Will you never have to give up those records?
Yeah, as I mentioned, this particular policy that we're bringing into place today, which will be in the spring bundle, will protect cabinet confidentiality. But what I also might add to this, it also protects the people of Ontario with respect to any sort of cyber incidents or information which may put our people or communities at risk, will protect the people of Ontario. I think that's an important part of this. I think we need to recognize as well. This is 40-year-old legislation, almost 40 years old. So updating it was well overdue. And again, we're going to be in line with the majority of the rest of the Canadian provinces and the federal government.
Does this mean that Premier's phone records, which have been subject to a lengthy battle, will now remain secret? Yes or no?
This, as I've mentioned before, this will, as this legislation is going to be outlined and it will be introduced in the spring bundle, will keep cabinet confidentiality. So any interactions of the Executive Council members amongst themselves will be confidential. And I think that's in the best interest of the people so that we can have candid conversations, important discussions, without any potential blowback in that sense. So what we are going to do, this information will be available through the public service. So any decisions that are made in the end will be available through the public service, FOIable.
You are basically, you lost a court case, you lost a court case, and now you're changing the goalposts with legislation to make sure you don't lose the next court case. Isn't that what's happening?
We're updating legislation that is almost 40 years old. We're modernizing it, bringing it in line with the majority of Canadian provinces and the federal government.
Why make it retroactive if you have nothing to hide?
Making it retroactive is bringing it in line with the legislation when it was initially brought out almost 40 years ago.
Minister, you and your colleagues are going to get a 4% pay increase this year. Why are the taxpayers who fund that pay increase, why do they not deserve to know what you're talking about when it comes to making decisions about how you spend their money?
Well, actually, I agree that the people of Ontario have absolutely every right to know about the decisions that are being made, and that's why they'll continue to be receiving information through the public service and FOI. And of course, our Premier, as many of you know, has been probably the most accessible political leader in the history of this country, in fact, maybe even the world. He interacts with people on a daily basis, and I certainly appreciate that. I get calls and texts from him at 11 o'clock at night where he would like me to contact an individual he was talking to. I've never seen a leader that's that accessible. So that's the kind of interactions you get with Premier Ford in this government.
It's okay for taxpayers to fund your raises but not know what you're doing.
Cabinet confidentiality has harmed the public?
Listen, I think everybody here knows that governments make important decisions. We've been through COVID. We deal with cybersecurity incidents. We have potential terrorist threats. There's many different interactions that happen in the province of Ontario, and many of those decisions need to be in cabinet confidence. I'm sure all of you would understand and appreciate that. That's in the best interests of the people of Ontario so that candid decision-making can be made amongst political staff.
They're always blurted out when we get the documents and it's protected by confidentiality. We don't see it in the documents, so why not just leave it at that?
Yeah, as I mentioned, this legislation is almost 40 years old. We're modernizing it and bringing it in line with the majority of the rest of Canadian provinces, Quebec, Alberta, federal government. It was long overdue. This legislation was written before email, smartphones, cyber threats. It was long overdue, and I'm pleased to be here today to introduce this to everybody.
Minister, can I just clarify something? Because the current law excludes cabinet records already. That's how the law works. If a decision, any communications involve making a cabinet decision, they're already not publishable. What is currently publishable and is not excluded is other information, discussions that don't relate to the final decision, but for example, possibly political considerations. Let's be frank, things that could be embarrassing to you and your colleagues. Why are you changing the law, which already protects cabinet confidence, to cover your backsides?
Yeah, as I mentioned earlier, this law was written 40 years ago. The methods of communication were very different. We had smartphones. We didn't have smartphones. We didn't have cyber threats. We didn't have cloud computing. I mean, it was when this legislation was written, it was 10 years before the Spice Girls were a thing. So that's how long ago this legislation was written. It didn't contemplate in the modern world that we're in today.
What do smartphones have to do with cabinet confidentiality?
Smartphones have everything to do with cabinet confidentiality because smartphones didn't exist when the legislation that we're changing today was written. So the world has changed dramatically.
How does that apply to making cabinet confidentiality stricter? I don't get how the two are related here.
Yeah, smartphones, like cyber threats, like cloud computing, did not exist when the legislation was written back in the 1980s. It's time to update our legislation for the modern world, and we're excited to be able to do that here today.
Just on that point.
That'll be all. Thank you.
Is this protecting against the release of
embarrassing texts and emails, Minister?